So let's talk about social media. Gosh. Where would my teenagers be without social media? They might read a book. Okay, what are we going to do? I thought I might just give you some a kind of one slide summary of the principles that sit behind how we manage the social media problems we see in the employment law space. We've got a whole lot of cases here that we can pick through. The law's a mess here, certainly the application. Actually, the principles are relatively clear. The application of the principles in particular cases is really messy. It's really messy, and what you'll see from the cases, frankly, is inconsistency, which isn't very helpful to HR managers. We'll pick out a few to try and kind of highlight that. But frankly, the most useful thing, I think, the most useful slide is this one. I'm going to try and do it in a sort of a slide for you. Okay, like how do we as lawyers work out when you phone me and say, this employee has done this on social media, can we sack him, or what do we do about it? If that's the kind of problem you might be encountering, where do we even start by unpacking that? Here it is. It shouldn't come as any surprise to anybody in a sort of Western liberal democracy like ours that employees generally in their private life are free to do whatever they like, right? They can hold unpalatable political views. They can engage in unsavoury conduct and post it to all and sundry, and they're free to. They're adults, right? They're free to do what they like. That's the starting point, right? And I really think that is the starting point. And I think Canberra, things get a bit weird in Canberra because we've got the public service here, and they're special. They're special legally because of the work that they do, and the courts have recognised that. But what the courts have said, including in a public service environment, is that any intervention by employers into the private life of their employees should be carefully contained and fully justified. That's a quote from a case called McManus and Scott Charlton, which was a public service case. So the idea is that you people have got enough on your plate, right? You don't need to be looking to dig unnecessarily into the inanity that may well be the private life of your employees. Really, you don't need to. The question is, when do we need to become involved? Because the starting point is in their private life, they're free to do as they please. In the workplace, of course, their conduct is necessarily constrained. How exactly does that work legally? Well, of course, if you may have company policies that direct employees how they might conduct themselves. So here at Bradell and Love, we have an employee social media policy, and it'll say, you can't go to various sites, you can't forward inappropriate content, etc. So that's a company policy. Good morning. Who is that jumping in? Please jump in if everybody's welcome to jump in. We've only got a small group, so let's make this session work for each other. If I hear somebody jump in, I'll shush up. What I can't see is my little question bar for reasons that escape me, Rachel. So if there's a question, just let me know and I'll shush up, right?
Yeah, no problem.
What I want to get back to saying in the work context, there's a few ways, what lawful ways by which employees' conduct is constrained. Firstly, employees, in exchange for their wage, they have to do what they're told, right? So it's called an implied duty of obedience. It's not written there in any contract of employment, but that is one of the implied duties of all employees. So you have to obey lawful and reasonable directions. And if we've got a company policy about how to engage in social media, then that is usually a lawful and reasonable direction. And if you disobey it, there can be lawful disciplinary consequences, right? So At work, your conduct can be constrained through that. That's a way. Another way is that all employees also have an implied duty of fidelity to their employer. Again, that's not written in your contract anyway. It's one of those, we kind of knew that, but we didn't know where we'll find it. It's an implied contractual term. That can thereby regulate what employees might otherwise be doing in their spare time. So, for example, if I'm setting up a little rival law firm in my spare time, that's my private life, yes, and therefore on McManus, on sort of general principles, I can do what I like, right? Well, no, because I have an implied duty of fidelity to Bradley Allen Love. There's some sort of no-go zones, and competing with my employer in my spare time would be one of them, right? So that's going to be another example of where out-of-hours conduct, kind of things we do in our spare time, can legitimately be within the purview of the employer. And lastly, employees also have an implied duty not to engage in acts that are fundamentally incompatible with the employment relationship. And that's the ones where that's the sort of, drug taking, alcohol, those sort of just what is that? I don't know, but you don't have a job here. We can't have people like that here. That duty is a lot, the bar to pass that's a lot higher than you think. It has to be fundamentally incompatible with your employment, looking at your duties, and it must be absolutely repugnant to the employment relationship, and utterly destroy the confidence. So these are kind of high bars that the common law sort of basis for employers to intervene in your private life is it's not as high as what you might think. So when we move into the social media world, you can see what we're getting is this blurring of the distinction between home or private life, work life, right? Social media is somewhere in between, sometimes over here and sometimes there, right? Depends where it's done, what device it's done, and to whom it's directed, those sort of things. So how do we in the HR business, how do we manage when it comes to our attention one way or another that there's been some sort of undesirable social media event by somebody connected with our work? How do we know when and how to intervene? Here it is. Here's the test. And it's kind of obvious, but I just see it missed all the time. And there has to be a relevant connection established between work on the one hand and the post on the other. Now that sounds really obvious, doesn't it? But just putting it back into the context, starting point is you don't go meddling in what people do in their free time unless there's really full justification for it. So what we're looking for is some sort of impact or connection between the work and the posting. So there's going to be two kinds of connections that's going to come up. The first kind there is often a temporal connection. So time, i.e. you did it at work. Okay, there might be either because of geography where it happened, or the duties involved, or the equipment or the platform used squarely brings it within work. So if I'm using, Bradley Allen Love doesn't have a Facebook page, I don't think, but if I'm using if there was a Bradley Allen Love Facebook page and I'm posting on that, then there's a connection right there, right? And it's kind of obvious, and you can see that. But you can see it gets more, and you do need to kind of ask these questions and look for the connection. There's also a link between the duties that you do. So posts that might be, there's such a thing as a generically offensive post, I suppose, but the duties you perform and the post you make, you might need to ask, well, who is that person? It makes a big difference if the person making the offensive comments is perhaps the CEO, right? Obviously, as opposed to, perhaps one of the administration workers. Why? because in terms of the reputation of the business, the impact on the organisation is likely to be greater depending upon if it's the CEO sending a message that this is the kind of place we are, right? So so you need to ask those kind of basic questions when you're trying to triage how to manage these things. Really what you need to do is look at the connection in that regard, and then look at is the post going to affect somehow the performance of that employee's work? And it might. I've got some examples where that has happened coming up. Or is it somehow going to affect the employer's business? And the key test here, I've just written there the rule in Rose and Telstra. You should pull that case out because it remains, despite the law being, it's 1998, but it still is kind of the test for when ultimate. Rose and Telstra wasn't even a social media case. I should point out it was a out of work punch up at a pub by a Telstra employee who didn't have any Telstra identification. He was at a pub and he got a bit upset in the local bar and punched somebody out, and Telstra sacked him, and it came up for an unfair dismissal case, and it was the first time anybody really started to think about that, because he was out of hours, so it wasn't at work. He wasn't identified as a Telstra employee. Telstra nonetheless took a kind of a dim view of what they thought to be antisocial conduct, but he was held to be unfairly dismissed because they said you have to look at where. Here's the test: is the out of hours conduct likely to cause serious damage to the employment relationship? Can it cause damage to the employer's interests, or is it incompatible with their duties as an employee? So looking at in the case of Mr. Rose, none of those things were satisfied, because perhaps if he'd had a Telstra uniform on or something, maybe it could have damaged the employer's interest, somehow led to some sort of reputational loss, but there was no evidence to the world at large that he even worked for Telstra. And it wasn't incompatible with his duties. I think he was a liney or something like that. He wasn't the CEO. He wasn't head of, the respect and conduct team or something. It was held to be unfair. Now, as I said, despite the fact it's not a social media case, it still remains the sort of go-to case for lawyers and frankly for you should be in trying to work out, is this something? Certainly, is it sackable? Number one, but going back, just unpacking that connection between what this person has done and how does it affect our business? Because honestly, in my view, I reckon for most of them, when you actually seriously think about that question, the answer will be it doesn't. It doesn't. And if Telstra had asked that in the case of Mr. Rose, they might have saved themselves a fair bit of bother, right? Like, okay, it's probably generally not a good idea to get drunk and punch people up, right? But why do we as an employer care? What he did on his Thursday night, the pub is frankly a matter for him and whoever he punched up and the police, right? It's just not our business, right? So what I do see, and I think I've said this before, but I do see HR, for I'm not quite sure why, but can often get a bit sort of bring their own sense of morality into the equation, and I suggest that the law does not support that. The law, it's not about the moral repugnance of what they're doing and they're sleeping around or cheating on their wife or doing all these ghastly things. That's not our business, unless it's criminal, of course. But we keep out of it. But if it will cause serious damage to the employment relationship, if it's going to damage our interests or our reputation, or it's incompatible with your particular duties because you're posting, for example, on social media how drunk you were, but you're a truck driver, right? Then we care. Then we care. But just if I could just leave you with one takeaway for this morning, I'd say to you, just pause when this stuff comes in, and often it's very fast and look at this guy's posting on social media, what are we going to do? And you don't always get a lot of time to think about it, but just look for, why do we care? Why do we as an employer, not because we're caring people, but why is this of interest to our business? What can it affect us or not? Because if it doesn't, just probably let it go. Righto. So that's sort of, I did want to spend a fair bit of time on that because that's the principles that sit underneath it, right? Now we might just move to a couple of cases that have sort of considered it. You might have heard a few of these before. Does anybody want to chip in at this point though? Is there anyone got any questions about the principles? Clear enough, right? I actually find them clear, but gosh, it's hard to apply. Really hard to apply because the combinations and permutations of social media use are really quite diverse, and of course they're changing. We just get a handle on the social media platform of yesterday, and there's a new one by today, right? So here's a couple of examples. I've had my clerk look through a few more recent ones. So this is the kind of thing people do, isn't it? The applicant who's the employee, so these are unfair dismissal cases. The employee sends a pornographic video to his fellow employees on his Facebook Messenger app. Super, right? And then he next day he makes a public post on Facebook and he says, sorry about that. I hit send all by mistake. So a post of mine was sent last night. It was posted to my FB friends and some got offended. I apologise for that. Hit send all by mistake, and he was dismissed, right? So what do you think? So they did apply the Rose and Telstra test in this case, but just on that, there's not enough facts there. Even I'm going, well, hang on, I've got a few questions. But he sends, so it's pornographic. We don't need pictures. We'll just take it on notice that it was pornographic, and he sends it to 19 colleagues via Facebook Messenger. Is that something that's of interest to our business? Is that connected enough to business? I actually don't know when he did it, but let's assume for the minute he did it in his spare time, right? And he wasn't using, he's using his own device, but he's got his 19 fellow employees of your business receive this. What do you reckon? Are we worried? I think I would be. 19 of them, right? Just the numbers worry me. If that means I've got 19 staff members receive some pornography from another staff member at some point in the last 24 hours or so. But he said sorry, right? So look, what happened with this? How do they unpack this? Sorry about the type font here. It's a little bit tight, but I'll happy to email out these slides if that's helpful at the end. But the Commission said, yeah, that's a fair dismissal. That's fair enough. There you go. The conduct did occur outside of work, and it didn't use work facilities. So if he'd done that on a work facility, right, like if we have a policy here that says you can't do that sort of thing, that would be, he'd be toast for that. But in his case, he didn't use work. He's using his own little device. And it involved employees who had self-selected to be Facebook friends. So that's interesting, isn't it? So this is their own. It's not a work Facebook page, as it were. However, the Commission held that it was the cornerstone of the employment relationship which led to the applicant having his work colleagues on Facebook and sending them the offending video in the first place. Okay. And said, look, this is not a case of an employer seeking to intrude too far into the private lives of employees. So the employer was simply attempting to regulate the appropriateness of an employee's private use of social media and was trying to respond to what it understood to be dissemination of pornography to its employees. Yeah, and worried about potential sexual harassment of its female employees. So they said, okay, there's the connection right there. There's a connection between the conduct and the workplace, and therefore fairly dismissed, right? I'm comfortable with that decision. That seems kind of probably wretched enough. Okay, so let's just, how much time we got? We got a little bit of time. Let's move on to a couple more examples, just to sort of be clear where the posts move into territory that's, I mean, some of these posts can be, pornography is one thing. Often we get posts that are they're defamatory, right? They're nasty about their bosses or their workplace. So I think my clerk summarised it there in a nutshell. She said, where the post is defamatory, bullying, contrary to workplace policy, or if it impacts on the employer's reputation in any way, you're starting to move into troubled water, right? So let's have a look at Mr. Stutzel. This is an old case, but it kind of was the first case where the full bench of what was then Fair Work Australia had to really kind of tackle with social media. So the world's moved on since 2012, but this was the first case that really got us all thinking about, how do we manage this? Mr. Stutzel was a truck driver working for Linfox, and he got fired he posted comments about his manager on Facebook. They were pretty nasty. His manager is a bacon hater. He made some comments about terrorism. There was some anti-Muslim sentiment there. And one of his managers noticed the comments, notified the person who the comments were about, and he makes a complaint, right? And they did have policies relating to EEO and diversity, right? So what happened with that one? He actually got off. He got off. In fact, he got reinstated. I think that's about the worst outcome an employer can get in unfair dismissal, isn't it? Not only is it an unfair dismissal, but you get reinstated as well. The Commissioner found, so this is back in 2012, interesting how the law changes, because I think this decision might well be interpreted differently now, same facts. But anyway, the Commissioner found that the comments were in poor taste, but they really seemed to be him letting off steam. And his evidence, Mr. Stutzel's evidence, was that he didn't know the posts were publicly available because his wife and daughter had set up his Facebook page. This is back in 2012. People were pretty green about how to manage this stuff, and he was a truck driver, right? So that kind of, I didn't understand how public it could be. Actually, when you read the decision, they gave a fair bit of weight to that. I don't think that would fly anymore these days, especially post-COVID, most people are a whiz at this stuff. So on that basis, and look, Linfox didn't even have a social media policy at that point. So on those facts, he was actually reinstated, and Linfox actually appealed that and lost. He had also been there for a long time. So, when you look at the unfair dismissal laws and they say, was there a valid reason? Did they follow a fair process, blah, blah, and then they have the last little criteria says, and look at all other relevant factors. In Mr. Stutzel's case, he'd been there a long, long time. So that might have been the thing that pushed him over the edge. So if you've got an employee with a short period of service, in other words, the decision may not have turned just on his social media conduct. It's also about his long period of employment. And I'll just pull that together at the end for you. But yeah, he didn't intend the comments to be publicly made. He gets off, right? But yeah, there's a comment there that even in the judgment, they acknowledge that as social media policies become more common, as users get more sophisticated, fair dismissal findings like these are likely to become rarer. So that's back in 2012, and that's exactly what's happened. So you wouldn't get away with that these days, I don't think. Yeah, we all know about Snapchat, don't we? So there's a couple of cases there. I suppose I wanted to move. I'll come back to this one if we've got time. I suppose I just wanted to do something. This one was kind of interesting. This is an airport. Mr. Singh worked for Aerocare Flight Support, which was something to do with, they're in an airport environment, right? So remember I said about the duties and the workplace, it can have some bearing on the outcome. So what might be inappropriate in one context might be different to another, depending on, where the workplace is. But he made some sort of comment that we all support ISIS. Yikes. And Aerocare was leading provider of aviation services. So he gets sacked for that on the basis that he's breached their social media policies, he's breached the conditions of his employment manual, and that these comments jeopardised Aerocare's relationship with its client and the brand. Mr. Singh, in fact, didn't support ISIS at all. His argument was that the post was sarcastic, and that actually, if they'd bothered to look at his history, you would have seen he actually felt completely the opposite. Regardless, that's not what he'd said, right? This was a sort of bit of an odd case, but it shows how, I don't know how much you've had to do with Fair Work Commission, but it's a bit of a hit and miss jurisdiction in terms of law and justice and whatever. But I got a bit confused by this decision. That ultimately they said that there wasn't a valid reason for the dismissal, right? So he works in an airport and he writes a comment, "We all support ISIS." He doesn't actually believe it. In fact, he was the opposite. But and the Commission actually agreed that in publishing the post, it could have had a result of causing harm to Aerogard. Regardless, in this case, it didn't constitute a valid reason for the dismissal. And they seem to have, this is a weird case, they focused more on the process of unfair dismissal. They only gave him 10 minutes for his interview and all this sort of stuff. So it's not a good case for social media in a way. It's more a case of how to mark up what would have been otherwise a valid, in my view, a valid reason for dismissal. Just had to do it a bit better. The investigation wasn't very thorough, etc. What I couldn't understand from that case was how anybody would have known. It was when Mr. Singh says we all support ISIS, where did he post it exactly? I couldn't quite work out from the decision where that came from, because of course I'm looking for the connection, right? If he put that on his private post at home and he's under Mr. Singh, unless it's obvious that he works from Aerocare, how would the world even know? Who would care, sort of thing? I couldn't tell from the decision how that was the case, but that's I'm suggesting to you that if these kinds of problems come across your desk, go back and look at okay. Somebody tells you that this post has been made. Go and do the work. Get the post. Hang on, who exactly can see it? As far as you can work it out, because it might be that, as offensive as the comments might be in there, if nobody knows about it or can't associate your business with it, why do we care, right? So going back to that original test. This one's funny. Kind of. It's kind of funny. We have to laugh in this job, don't we, folks? Because our people do silly things, don't they? But this is a bit of a car park, Donnie, where we've got a little bit of drama between a couple of colleagues who aren't enjoying each other's company, and it ends in Miss Natoli. So she's feuding with Ms. O'Connor. For whatever reason, she drives a partner's car to work, and that car gets damaged in the car park quite significantly. Ms. Natali, so she's the one whose hubby's car's damaged. She blames it was obviously you, right? She blames her for the damage, and texts her to vent her grief. She says, "You're the only one giving me grief at work. My car was parked all day at work, and it was parked near the smoking area, which you utilised. You selfishly damaged a 60 grand vehicle and caused 6 grand of damage because of your childish behaviour. This isn't over, Charlene. You have no idea how furious John is." Okay. I've seen texts like that, right? And then on a Facebook page, she posts, "A nasty piece of work in my workplace decided she would teach me a lesson by scratching John's $60,000 vehicle, which I was borrowing yesterday. The little didn't like being told to complete her duties before the month end, so this is the result. John's rightly furious, and so am I. Watch out." So there's a little bit more to it than that, but that's the essence of the social media exchange, and she gets fired, and she doesn't. She takes it to the Fair Work Commission for dismissal, and they're not having it. They say that the posts and the text were definitely in relation to her employment. And I think that's kind of obvious, and that the effect of the text and the Facebook had a direct connection on the working relationship between the Ms. O'Connor and Ms. Natoli, and therefore what could have been seen to be private has been brought within the purview of the workplace, and she was validly dismissed. Interesting, when you read these cases, you get a flavour of the sort of personal peccadilloes of the commissioners, and we got a commissioner there who's pretty unimpressed, right? It never ceases to amaze me that employees often plead a lack of training or a lack of training of self-evident unacceptable conduct, such as bullying or harassment, to justify in some bizarre way their behaviour. She said she hadn't received training in respectful conduct, so therefore she couldn't have worked out that that kind of thing was unacceptable. So that didn't sway the commissioner. And the commissioner also made the comment about the fact that, I continue to be baffled by employees who say things on social media that they know they wouldn't say face to face. It's that whole anonymity or perceived anonymity, and sort of, I wouldn't say it to your face, but I'm happy to post away. And we're all seeing that, right? But again, the commissioner was not impressed and said that the standard's the same, right? Incomprehensible and foolish. Too bad, you're over. I'm just going to finish now on the case of Ms. Banerjee. I'm just going to quickly just go through that. Sorry, I'm just flicking through because I'll just wrap this one up, because we've talked about Ms. Banerjee's case before. I think you've probably heard about this because this is a Canberra case, right? And this is a public service case. But it's interesting for all of us in HR because Miss Banerjee was a relatively, she's about an APS 6, so that's kind of mid to lower tier public servant working in Department of Immigration, and she did have a role in communications for the Department of Immigration. That's her day job. In her spare time, she's anonymously tweeting, making tweets that are quite critical of the Commonwealth's immigration policy on border protection, things like that. They were abusive and aggressive tweets, right? They were pretty, and there were lots of them. I think scores of them, I think 60 or so tweets, maybe more. But she's anonymous, right? They're mean to Commonwealth's mean to bone people, etc. Those sort of type tweets on the one hand. Day job, she's a comms officer in the Department of Immigration, right? She was ultimately dismissed from her employment. I don't want to get too caught up in that. You guys are blessedly free of the APS code of conduct, so I won't bore you with the ins and outs of that. But ultimately, look, she was dismissed. She didn't lodge an unfair dismissal claim. She should have. I reckon if she had, she would have not only won, but she would have set a wonderful precedent for a lot of public servants in Canberra. What she actually did is put a workers' comp claim in because she got all for depression and anxiety arising from her dismissal. And you might know in the workers' comp space that claims of that nature, if your injury is a mental health injury and it's caused by work, they'll knock it back if it's a result of reasonable administrative action, because we all get stressed at work, right? But if the stress was caused by unreasonable management action, then you'll get compensation for it, right? So she has this fight in the workers' comp forum about whether what happened to her was reasonable or unreasonable, which is a little bit different to the unfair dismissal jurisdiction. So she's kind of in the wrong legal forum to start with. I think she acted for herself actually, but she had all these kind of weird arguments about so she goes to the workers' comp forum, it's knocked back, and then it's appealed to the High Court, right? And so the High Court have to rule on, she says, but I've got this right of free speech, right? It's in the Constitution, right? I can say what I like. I'm anonymously tweeting over here, and I lose that. I'm allowed, I'm a citizen, I'm allowed to comment on the politics of the day. That argument actually failed for her on the basis that ultimately, because she's a public servant, I said they're special, they have some special obligations that it's expected that our public service is apolitical and whatnot. And so in her particular case, there were limits on her implied freedom of political communication, and therefore ultimately the Commonwealth hadn't done anything unreasonable in that regard, right? We don't want to get too caught on that. The reason this case is really interesting for me is because it was anonymous. She did not disclose her identity. They had to do a whole lot of digging to find out it was her, right? My view on this one is it's Commonwealth overreach. You know, nobody really cared. She wasn't the Deputy Secretary. As I said, she was an APS 6. Any sort of, any letter she had to, you know, any hand on any piece of paper that she would have written would have been checked, you know, 20 times up the line before it went out the door. So to suggest that somehow her obvious sort of political views would mean she couldn't faithfully perform her duties, I thought was a little bit far-fetched. But look, as I said, she never ran it as an unfair dismissal. Had she run it as an unfair dismissal, she might have got somewhere, because I think that this case really tests the boundaries of that private work divide that I kind of started with in the first place. I suppose I just want to finish off. Might just finish off. Time at 10:02. Might just finish off with this. You know, ultimately, you know, what would I say? The three things, the three takeaways here that I see. There's more cases there, and when I ask the clerks to pull it out, I just get the cases are all over the place, right? It's really hard to get, other than like those initial comments I made, hard to get a common thread. You do see a lot of moralising, and you see a lot of reactions to current trends, right? But ultimately, look, I think there's kind of three takeaways for those of you in HR from an employer's perspective. How do you manage this? Look, three things you can do. One, as I said, just focus on this. Why is it our business? The connection between what's happened and our business. Is there one? And is it one that we're seriously worried about it? Or is it just somebody letting off steam or just doing stupid stuff in their private life? Okay. Really focus on that, because that, and really think about that, like really unpack the dimensions of connection there. That'll be the first thing I do. Second thing I do is have a social media policy for what you can do at work, and you can extend to outside as far as it connects your business. Make sure you've got a good one. We can help you with that if you need it, but you should have one, because that'll help you. If you need to sack them, it gives you another limb to your dismissal that it's offensive and blah blah blah, and it's in breach of our social media policy. That seems to have quite some sway with the Fair Work Commission. Lastly, where employers can trip up here is that even if they've looked at the connection, they've made a prudent assessment that yes, this is legitimately affecting our business or imminently likely to do so, or our reputation. So the connection box is ticked. And we look at our social media, and yes, what they've done is in breach of our social media policy, tick. We're still got to comply for employees below that 153,000 threshold. We're still going to have to effect a fair dismissal. So what I'm saying to you is that the nexus of the social media policy will give you the valid reason for dismissal. But as we probably all know now, from to the extent the unfair dismissal laws apply, so you're below 153,000 people, excluding casuals and whatnot, that you'll have a valid reason, but you still got to affect your fair process, right? So you have to get them notification, you give them an opportunity to respond, you allow them to have their support person present if they want, and then just missed the key one. Sorry, I'm just looking at the last dot point. There should be one more dot point on that slide that says, and it's section 387 of the Fair Work Act, that says, well, is there a valid reason? Was the employee notified? Were they given an opportunity to respond? Were they not unreasonably refused a support person? And then the last one says, and any other relevant factor. That is that you must consider their continuity, how long they've been there, at the economic hardship that'll inflict upon the employee. Those kind of factors that we're kind of familiar with. Just you can slot it into your knowledge data bank. That actually fits in as it's actually a separate criteria that every commissioner must look at when assessing whether a dismissal was unfair. They will literally go through every dot point on that slide. And there's one more that's been left off that says any other relevant matter, and they are the kind of hardship to the employee type provisions. Continuity, particularly how long they've been there, what their duties are, and what's the impact going to be. So if you've got a kind of 59-year-old truck driver that's got no other, in a country town, it's got no other prospect of getting any sort of sensible employment in a COVID-depressed environment, right? Obviously, that's a factor that is proper and required of the Commission to consider in the whole dismissal. So, if you're worried about that and it's borderline, you might want to consider mercy over justice at that point if you don't have the appetite for a unfair dismissal hearing. Okay, look, it's 5 to 9. I think I've said probably way too much. Is it time for me to be quiet, Rachel, and let you see if anybody wants to ask some questions or tell us what's coming up next?
Yeah, of course, no problem. So if anybody has any questions,
Sorry, David Wedgwood. Yep.
David?
Just a point on the Banerjee case. It's frequently misreported that a component at issue was, quote, the implied freedom of speech in the Constitution or the implied right to political communication. And that shorthand gets that completely wrong. The precedent case is, in fact, a local case. It's Capital Television versus the Commonwealth over the banning of political advertising during election campaigns. And so it's a very limited, very narrow case. There is no freedom of speech in Australia. There is no absolute right at an individual level of freedom of political communication in any decided law case. So
Correct.
It's just a often misreported and misunderstood case.
You're right. Thank you. Thank you very much. That's actually quite correct, David. And I don't know if our colleague Kieran Pender actually runs a separate session just on this. You're right. It's simplistic to the point of being misleading, isn't it, to say that? But if anybody's interested in those exact points, David, we will. Kieran Pender is my colleague that speaks a lot about this stuff. But it's an interesting and evolving area, and yes, it's not helped by the confusion that's generated, is it? But keep your eyes out for next year. We will do a refresher session on this, probably towards the end of 2021, and when COVID's settled, right, we've all got our vaccines and we can start focusing back on these sort of bigger picture issues. So thanks, David.
Okay, anybody else with any more questions? No. Nobody? No. All good. Oh, no. No, okay, no problem. Okay.
What happened there, Santa?
So thank you everybody for joining us this morning. I hope you enjoyed the presentation. If you've got any further questions that you think about, please feel free to contact us via email, telephone. Our next HR Breakfast Club session will actually be in February, not January. Like I mentioned before, we are hoping to get back to face-to-face meetings as soon as possible, but we'll keep you informed. A calendar invite will be sent out shortly, or you can RSVP through our website, hrbreakfastclub.com.au. We hope you have a wonderful Christmas and Happy New Year, and we hope to see you all next year and very soon. Thank you very much, and goodbye.
Thanks, Gabby.
Thanks, you're welcome.
Thank
Scott.
you.
All right, Merry Christmas, everybody.
Thank
We're
you.
nearly there, right? A few more days, folks. Go get them.
It is. Merry Christmas.
Merry Christmas.